Hey everyone, welcome. I'm absolutely thrilled you're here for today's explainer because we are unpacking a massive, often completely invisible shift happening right now in the Australian business landscape. We are talking about AI data sovereignty. Now, we all know boards want progress, your competitors are moving fast, and AI is promising these literally incredible productivity gains. But as we head deeper into 2026, a critical realization is really hitting the market. Adopting AI as this quick productivity shortcut without addressing where your data actually physically lives, well, it's creating massive legal exposure. Okay, let's dive into this. I want you to picture something for just a second. Imagine you're sitting at your desk in Sydney or maybe Melbourne, Brisbane, wherever. You copy a client's financial summary or maybe a sensitive contract clause, you paste it into an AI prompt, and you hit enter. Have you ever actually thought about the exact physical journey of that data the millisecond after you hit that key? Here is the locational reality, and it's a big one. Cloud computing isn't magic. It's not just floating in the sky. It's physical infrastructure. When you type that sensitive client data into most public off-the-shelf AI tools, that information literally leaves Australia. It gets processed on servers located in the United States, very often in places like Virginia, Oregon, or Iowa. And this isn't just some privacy setting you can quickly toggle off in a settings menu. No, it's the fundamental built-in architecture of those platforms. Bottom line, if your vendor's servers are in Virginia, your client's data is in Virginia. So, to help us grasp exactly what this means, here is the roadmap for our explainer today. We'll cover 1. The offshore AI problem, 2. What Australian law says, 3. The Virginia problem explained, 4. Industry risks and realities, 5. What sovereign AI means, and finally, 6. Safe AI implementation steps. Let's get into it. Section 1. The offshore AI problem. Experimentation versus operations. The distinction between these two approaches matters so much more than most organizations want to acknowledge. Look, AI experimentation is great. Teams try out tools, they run internal demos, they test use cases on non-sensitive data. It's totally low stakes and highly valuable. But operational AI? That is what happens when those systems become part of the actual work. When an AI tool starts drafting real client advice or touching live financial workflows, the accountability context fundamentally changes. What usually happens is, a tool that was initially adopted by just one person to, say, summarize internal meetings, dangerously transitions into processing real client data. There was actually a Brisbane-based financial services firm that found out 3 of their 7 internal AI tools were processing client data without any central governance view at all. None of it was malicious or intentional. It was just a quiet slide from a harmless pilot into risky production. And when that quiet slide happens using unsecured offshore AI platforms, you trigger exactly 3 compounding risks. First up, data exposure. Client data passing through public AI tools represents a huge potential breach of confidentiality. Second is compliance drift. When AI-generated outputs aren't logged or reviewed through proper established processes, you completely lose your audit trail. And third, operational fragility. Adopting tools team by team, without a common architecture, it creates this fragmented patchwork that is literally impossible to govern. These 3 issues create a domino effect. And the scary part, none of these require a malicious hacker to become a massive problem. They are purely structural risks. Section 2. What Australian law says. Navigating the regulations. So the crucial point here really centers on Australian Privacy Principle 8. Before you disclose any personal information overseas, you absolutely must ensure the recipient handles it consistently with APPs, or you need direct, explicit consent. And here is the kicker, right? Simply sending data to an offshore AI model for processing legally counts as disclosing that data under the Privacy Act 1988. It doesn't matter if no human being at that tech company ever actually reads it. The machine processing it, that counts as a disclosure. If you're using offshore AI, you are intersecting with a very sharp regulatory environment. Under the Notifiable Data Breaches scheme, if your offshore AI provider suffers a data breach that happens to include your client data, well, that instantly triggers serious notification obligations back home. You have to formally notify the Office of the Australian Information Commissioner, the OAIC, and the affected individuals. The accountability stays entirely with you, the organization, not the tool vendor, you. Section 3. The Virginia problem explained. A clash of jurisdictions. Now, what's really interesting about this clash of jurisdictions is what actually happens once your data is processed in Virginia. Virginia-based courts can subpoena it. Under the Cloud Act of 2018, The US government has greatly expanded abilities to compel the disclosure of data stored by US companies. US federal agencies can literally issue national security letters to access that data completely without your knowledge. Suddenly, data protection obligations under US law apply to that data, which fundamentally alters your indemnity position with your own Australian clients. Kind of wild when you think about it, right? Section 4. Industry risks and realities. High stakes in professional services. When we break this down by industry, the stakes become crystal clear. Say you run an accounting firm. Just typing client data into an offshore prompt can instantly breach the tax file number rule of 2015. If you're a law practice, well, case law shows that storing data with third-party offshore providers can actually destroy solicitor-client privilege. And in financial advice, ASIC's regulatory guidance and the financial accountability regime require incredibly strict audit trails for best interest reasoning. You simply cannot afford to have that reasoning generated on unlogged offshore servers. Section 5. What sovereign AI means, the Sydney solution. So, sovereign AI is not just some flashy tech buzzword. In the Australian context, it has a very specific literal meaning. Sovereign AI means AI systems built on infrastructure that is physically located and legally governed right here in Australia. It means using providers covered entirely by Australian law. It is a highly practical commercial procurement decision to keep your data legally protected on Australian soil. And this brilliantly illustrates what it actually looks like in practice. Deploying sovereign AI means building on AWS Sydney, or the Google Cloud Sydney region, not their global regions. It involves executing Australian data residency agreements where it explicitly states, in black and white, that data does not leave Australian jurisdiction. It means ensuring that every single action is logged, access controls are airtight, and your firm's data absolutely never leaves Australian soil. I absolutely love this quote from our sources. Governance is not a constraint on AI adoption. It is the infrastructure that makes speed sustainable. Adopting sovereign AI isn't about slowing your business down. Actually, scratch that. It's the exact opposite. It builds a compounding commercial advantage. You completely avoid the fragmented technical debt of scattered off-the-shelf tools, and instead, you gain a highly scalable, fully compliant system. Section 6, Safe AI Implementation Steps, from pilot to production. Let's move to and see how this builds a really secure foundation. Step 1, conduct a capability and data audit. Map exactly what data you hold and what your regulatory obligations are before any tool goes anywhere near production. Step 2, establish a data processing policy from the top down. You have to decide which categories of data can be processed by generic public tools versus secure sovereign Australian tools. And step 3, build architecture for auditability. Use the discover, design, and deploy methodology. Map your workflows, design your human review checkpoints, and then deploy on safe infrastructure so you can audit every single AI output. The ultimate payoff here is super clear. If you adopt tools informally, ad hoc, you're just building technical debt. But if you invest in a common data layer and unified governance today, you create a massive compounding advantage. When Opera, ASIC, and the federal government tighten regulations, and trust me, they are doing that right now, businesses with a sovereign AI framework will absorb those changes with incredibly low friction. Meanwhile, competitors are going to face a highly disruptive, frantic catch-up. So I want to leave you with this question. I want you to really evaluate your current internal operations honestly right now. Are you building AI as a genuine business asset, or is your current setup just an ongoing, completely unmanaged liability? If you want to move from curiosity to real capability without accumulating all this risk, you need to map what you have right now. Your next step is to download the Sovereign AI Trust Framework. Use it to map your workflows, stop that quiet slide into risk, and start securing your AI infrastructure on Australian soil today. Thank you so much for joining me on this explainer, and I will see you next time.